it's not possible to leave our Islamic selves separate from our democratic selves, separate from our constitutional selves. That as individuals living in this context, each of those parts of ourselves are entwined, are connected, are living together.
Sometimes our brothers, our husbands feel like we have given them so much entitlement. They feel like they do us a favor by opening up the space.
We sort of have to navigate Islamic laws, what our aspirations are versus what the law of our land allows.
In this fourth episode of Musawah's second season, we will hear from Dr. Fatima Seedat and Rumana Mahomed from South Africa and Zabib Loro from South Sudan. Together, we will explore issues surrounding inheritance and property laws, especially following divorce or death of a spouse, and the impact they have on women's rights in both countries. We will examine how civil and Islamic inheritance laws affect women's financial rights after divorce. We ask, why do these issues matter? And what changes are needed? I'm your host, Rehema Namkose, and you are listening to Musawah Podcast, a space dedicated to deconstructing family and personal status laws, understanding Muslim women's rights, and exploring what it takes to achieve dignity, equality, and justice for all. How do legal systems deal with Islamic law? Looking first at South Africa's legal system, we find that it is premised on civil law while respecting religious customs. This means that Islamic law is not fully recognized as part of the national legal system, but it still allows Muslims in South Africa to follow their beliefs whilst remaining within the bounds of national law. For Muslims who represent the minority in the country, marriages and inheritance practices are respected as part of religious freedom, but they do not always have legal standing unless registered or validated under civil law. Yet, some Muslim couples feel that registering their marriage under civil law conflicts with their religious beliefs. This creates a tension between fulfilling their religious obligations and ensuring they have legal protections as South African citizens. On this matter, Dr. Fatima Seedat starts off. She is a scholar activist. Her areas of work focus on Muslim family law, gender, and legal subjectivity studies. She's an associate professor in the Department of African Feminist Studies and is also director of the African Gender Institute at the University of Cape Town.
When you're inside your house, you're still a citizen inside your marriage. We have judicial bodies in South Africa, which people refer to as authorities for Islamic law. Those judicial bodies do not have a legal standing, so to speak, in that they cannot enact or implement or enforce any kind of ruling that they make. So people literally sit between a judicial body that might have made a ruling about something, an Islamic law or a Sharia-based ruling on something, and that cannot be enforced. It just cannot be enforced because you do not have the legal mechanisms for it. That is the kind of frustration you're sitting with daily. If someone was to get married under Islamic law in South Africa, we're in a context where the actual marriage itself, in order for it to be recognized, would have to go into a court. If you wanted to claim any benefits or any consequences of that marriage, until recently, you'd have to go into a court and argue for your marriage, that your marriage actually exists, in order to be able to claim any consequences of the marriage.
Islamic marriages are not automatically granted the same legal status as civil or customary marriages under South African law. This has implications for Muslim legal rights when it comes to property, divorce, and inheritance, or even problems in enforcing marital rights, such as in cases of spousal abuse and domestic violence. For example, in a civil marriage, spouses automatically have certain rights to each other's property and inheritance. However, a couple married under Islamic law who choose not to register it as a civil marriage might not have any legal claim to the property or estate in the case of one partner passing or if they choose to divorce. This also leads to complications in child custody, spousal support, and division of assets, as the civil courts may not consider the Islamic marriage or divorce for that matter valid. Rumana, a lawyer, runs a niche practice in Durban, South Africa. As a fiduciary practitioner, she specializes in the winding up of deceased estates, wills, and trusts. She also consults actively on Islamic personal law, marriage, divorce, and inheritance. She explains these challenges more in light of inheritance laws in South Africa.
Our constitution gives us the freedom to practice our faith, but there's no entrenched law recognizing Islamic law. So in terms of inheritance laws, in South Africa, we don't have fixed heirship rules. So when a person dies, there isn't this automatic succession law or a standard law that applies to everybody. We have what we call the principle of the freedom of testation. We have the right to say whatever we want to in terms of our will, to bequeath or distribute our wealth in any way. And what happens is that if a person passes away without a will, that's when government steps in with a sort of formula as to who inherits what. One has to consider what is the civil law matrimonial property regime, for starters, and then you determine what the consequences would be in terms of the distribution of the wealth. Where there is no will, and if we say the person died intestate without will, then the Intestate Succession Act has a certain formula and takes into consideration the spouse and the number of spouses and the number of children.
This is the current legal reality in terms of inheritance. What about in the cases of divorce? How does civil law interact with questions of property distribution?
There are 3 different property regimes which have to be dealt with. The first being the in-community of property regime, where spouses share assets and liabilities equally, which means that they will have an equal sharing into assets that they acquire, be it property or any other form of asset, right? Then we have an option of entering into a regime where it's 2 separate estates. So whatever the husband owns is his, whatever the wife owns is hers, and it's kept independently. The third, in a sense, is a hybrid. It's where you start off your marriage with whatever you've had, whatever you acquired before the marriage remains yours, but for the subsistence of the marriage you share. So that's what we call the out-of-community of property regime with the accrual. Okay, so whatever's accrued during the marriage is then shared. So when you get to the end, either death or divorce, one has to look at the matrimonial property regime first to determine how the proprietary rights are sort of distributed or allocated.
A Muslim individual must draft a will in accordance with Islamic principles to specify that their estate is to be distributed according to Sharia law. If a Muslim dies without a will, their estate will be distributed according to the Intestate Succession Act, which might not align with Islamic inheritance laws. And while courts may consider Islamic principles in some cases, the ultimate authority is South African civil law, particularly as it aligns with constitutional principles. This existing legal structure has an impact on Muslim women and children.
There are tools, the wives in particular, can be excluded from receiving benefits because of the discretionary nature of distributions. So it becomes very important to understand the regime and also what your rights and obligations are in terms of vehicles like trusts and things like that. In estate planning, what we've been encouraging women to do is just to keep a record of this so that on the demise of the husband being the primary income earner, the wife's claim becomes a liability against the estate and not part of her inheritance. And in exchange for settling that liability, she could claim an asset in the estate. So then it just sort of gives her, it buffers her in terms of her security and supplements what, financially what she perhaps needs for her maintenance going forward.
Such complexities can lead to financial insecurities for women. This is largely due to limitations in property rights and inconsistent access to maintenance payments. In Muslim minority countries like South Africa, as well as Senegal and Uganda and many others, this issue is compounded by other informal challenges where divorce practices may bypass legal protections, resulting in women losing access to marital property and struggling with poverty. Religious practices can also restrict women from securing property rights after a divorce, leaving them financially vulnerable with no guarantee of spousal support for child maintenance. As Muslims function within a broader legal framework that is primarily based on civil law or customary law, they typically follow their religious practices, but must still navigate a legal system that is not centered on their faith, which in most cases can lead to inconsistent protections for Muslims. This is why Muslim minority contexts need to be understood and analyzed from within the larger legal tradition in the African context. Looking at South Sudan as another example, we can see how these inconsistencies can lead to complications of managing wealth distribution, often leading to disputes or increased costs, and leaving women at a more vulnerable financial situation. As the country operates under a secular legal system, Muslim marriages in South Sudan must be registered with civil authorities to be legally recognized. Without this recognition, which some Muslims do not choose, women struggle with issues like divorce and inheritance, as their marriages are not automatically validated by the state. Zabib Loro, a feminist, human rights activist, researcher, and the founder and executive director of Women for Justice and Equality from South Sudan, tells us more on the importance of women's financial literacy and independence.
I usually tell women that having their money is their security. I believe that when someone is empowered and they are able to make money of their own, or they are able to count money that is theirs, then women will be able to establish businesses. When these resources are equally distributed within the communities, then we see that if it's women equally participating in community development, in their own personal development, and also support to the development of the country, since they will also be able to contribute in paying taxes, educating children in schools, paying bills, then we see that economic empowerment is achieved. I'll talk of, out of experience back home, is I see a lot of women, when they are not economically empowered, then the rate of gender-based violence is at an increase. But when they have their money, somehow there is that reduction in gender-based violence, and this money becomes their number one security, while in relationships, as they will be able also to contribute some bills within the family, and then they'll be equally able to educate their children, whom sometimes society neglect, whom sometimes their own fathers have left behind and maybe gone. We have societies where after marrying this girl with 150, 200 cattle, that is the end of you seeing this person contributing to you. And whatever he contributed was to the family. The moment you step into that marriage, then you are supposed to work and facilitate all the affairs of this family without bothering this man. So that becomes unfair.
Islamic law, when carefully implemented and combined with civil law, can provide significant financial security for women. First, women need to negotiate the marriage contract, fair mahar, register under civil law, draft Islamic wills, and ensure maintenance agreements are in place. Discussing and agreeing upon conditions in marriage contracts is good for the couple, the marriage itself, future children, and both families. Especially because the process of adding conditions can reduce or prevent conflict within marital relationships, strengthen marriages, and support families.
The research shows that the majority of women's incomes are reduced by at least 30% after divorce. And so inevitably divorce reduces a woman's financial capacities. So what we are really interested in is how to avoid that. We try to see what the elements are of Islamic law and Islamic ideas of marriage that we might be able to use. The two things that we have been able to use, and we know it's not just us, but other people are also able to use it, is the concept of mahar, which some people speak of as maskawi or sadak, and then the ideas of nafaka, which is the maintenance of a wife during marriage. In terms of mahar was token, right? It was symbolic. It was not substantial. Now, that's very different from other parts of the world where mahar is actually very substantial. We know that there are studies that have told us about how mahar is negotiated in absolute detail in some parts of Egypt, for example. In other parts of the Arab world, mahar is negotiated very finely. It is paid in the form of property. It is paid in the form of services. It can be paid in the form of different kinds of assets, gold, money, and other things. So our South African practice has not been that until recently. Now, recently, people are negotiating more significant mahar. The idea of deferred mahar obviously helps because it dissuades or discourages instant talaq when there is a significant mahar that must be paid at the point of talaq. So if we're trying to protect the kind of vulnerability that is inherent to nikah marriage as nikah has inherent in it a vulnerability of the wife because of the fact that talaq can generally be pronounced instantly and unilaterally.
What is the difference between mahar, deferred mahar, and nafaka? And how do they ensure a Muslim woman's financial security? Mahar is a mandatory gift or payment given by the groom to the bride at the time of marriage. It provides financial security to the wife and is her exclusive property to be used as she wishes. It is also a symbol of respect, honor, and responsibility. And deferred mahar is the portion of the mahar that is agreed to be paid by the husband to the wife at a later date and is often due upon divorce or the death of the husband. Yet specific terms are usually outlined in the marriage contract. Nafaka refers to the legal obligation of the husband to provide financial support to his wife during the marriage and in some cases after divorce. This support includes basic needs such as food, clothing, housing, and other necessary expenses. Nafaka can sometimes be allocated to the period that is referred to as IDRA, which is a specific waiting period that a woman must observe before she can remarry after divorce or the passing of her husband. So, how is nafaka actually calculated? Well, it's not one size fits all, and it can vary depending on where you live, but generally, there are a few key factors that courts and religious scholars look at. First, we've got the husband's financial capacity. Now, this simply means, what can he afford? The idea here is that nafaka shouldn't push him into financial hardship, but he does need to provide for his wife in a way that's fair and sustainable. So, his income, assets, and financial obligations all come into play. Then, we have the wife's needs. Nafaka is meant to maintain her standard of living. Think of it like this. If during the marriage she was accustomed to a certain lifestyle, let's say housing, food, clothing, and maybe even healthcare, the husband is expected to continue providing that. The key here is that her standard of living doesn't suddenly drop just because there is a separation or divorce. Now, we have the dependents. If the couple has kids, this can add another layer to the calculation. Supporting the children often means the husband's obligations extend beyond just his ex-wife, which, of course, can impact the overall amount he's required to pay. Another interesting factor is the duration of the marriage. In some cases, the longer the marriage, the more support might be granted. But that's not always a hard and fast rule. And finally, we have to consider the wife's financial standing. In some interpretations, her own wealth or earning potential might be looked at. Though traditionally, nafaka is solely the husband's responsibility. But again, local laws and courts might tweak that depending on modern understanding and practices of gender equity. Different countries apply these rules in different ways. For example, in Egypt, the court looks closely at the husband's income and the wife's basic needs to determine monthly allowances. And in places like South Africa, where civil law may also come into play, judges might even factor in inflation or the cost of living. So, to sum it up, calculating nafaka is really about balance. Balancing the husband's ability to pay, the wife's needs, and any other dependents involved. And of course, it varies widely based on location and the specifics of each case.
She's put all her energies into making the home, looking after the family. Now for her to be in a situation where she must go out and earn, 3 months is not sufficient. 3 months of, or 3 menstrual cycles worth of finances is not sufficient, that she would need a lot more. We want to maintain the legal independence, the legal subjectivity of the individual who's been divorced. And so we want to be able to empower them to continue to live a full, complete life. And providing economic stability is part of that.
There have been legislative efforts in South Africa to recognize Islamic law, specifically when it comes to Muslim marriages. In 2003, a push to pass a Muslim marriages bill in South Africa was introduced. This would fully recognize Islamic marriages under the law. If passed, this would address a lot of issues around inheritance, divorce, and polygamy, and offer much-needed legal protection for Muslim couples. Meanwhile, in South Sudan, advocates are fighting and mobilizing for both the family law and gender-based violence bills to become passed into laws. Although not Muslim-focused, such legal reform would impact all South Sudanese women and will pave the way for more legal protections. In both countries, Muslim communities are dealing with the difficult challenge of practicing their religious traditions within a legal framework that wasn't built with them in mind.
I'll say that it is not an easy thing, though it is something that will only come to pass if the Muslim community come out and speak about the religion positively. There is no way, nowhere in the Quran that Islam rejects women empowerment, that Islam rejects inheritance for the women in Islam. There is no way that Islam refuses a woman to have her own money. Instead, Islam encourages women to have their own money, women to own property, women also to be educated.
South Africa is unique not only globally, but also continentally, in the sense that of the way in which Islamic laws work here. We're a minority Muslim community. We're a constitutional democracy. We're one of the few spaces on the continent where customary marriage is recognized and legal, where same-sex unions are recognized and legal, in addition to which there is the possibility of monogamous civil marriage. Interestingly, also in this context of diversity, we're still struggling with the recognition of Muslim marriage. With the advocacy work that we've been doing, we are now at a point where you can go to the court and you can request a divorce, even if you don't have a civil law marriage. If all you have is an Islamic law marriage, you can go to the court and you can technically ask the court to adjudicate on a divorce. But this is so new.
When studied properly, Islamic law can be read through the principles of Sharia, in which equality and justice are inherent values. Muslim minority contexts present us with a unique challenge that can allow us to move towards reforms that work for our current lived realities in all their diversity and complexities. It is time we work together and build egalitarian Muslim societies. This is our final episode of Season 2 of the Musawah podcast. Thank you for tuning in. I'm your host, Rumana Mahomed, Senior Regional Program Officer, Sub-Saharan Africa at Musawah. You can learn more about our work in the show notes.